Hello, hi, and welcome. So, now the topic is company to report satisfaction of charge. So, satisfaction of charge has to be reported to the register of companies by the borrowing company upon payment of money back to the lender. So, the satisfaction of charge, once it is reported, the Register of Companies will make a necessary entry in the Register of Charges with respect to the satisfaction of charge. So this particular aspect has been given under section 82 of the Companies Act 2013. It requires a company to give intimation of payment in full of any charge earlier registered to the registrar in the prescribed form. The intimation needs to be given within a period of 30 days from the date of such payment or satisfaction. So here 2 points student have to remember. It is the borrowing company which has an obligation to intimate the register of companies. What is to be intimated? Payment in full of the charge earlier registered in the prescribed pro forma. The same intimation needs to be given within the stipulated period. The stipulated period to intimate the register of companies is 30 days from the date of such payment in full to the lender. So notice to the holder of charge by the registrar. Notice to the holder of charge by the registrar. Here the holder of charge is nothing but the lender. So here what the registrar will do is that registrar will check with the holder of charge and find out that the amount in full has been paid by the borrowing company to the lender. So on receipt of intimation, the registrar shall cause a notice to be sent to the holder of charge, calling upon him to show cause within such time as specified in the notice, but not exceeding 14 days, as to why payment in full should not be recorded. So the registrar will give a notice to the holder of charge or to the lender, a notice which requires him to show cause not to record the satisfaction in full within a period of 14 days. So if no cause is shown by the charge holder, if no cause for not to record the satisfaction is shown by the charge holder, the registrar shall order entering of a memorandum of satisfaction in the register of charges kept by him. He shall inform the company of having done so. After entering that satisfaction in the register of charges, the registrar will communicate the same to the borrowing company. The same is being recorded. However, no notice is required to be sent by the registrar to the charge holder if the specified form was signed by the holder of charge. See, the registrar is to be given an intimation in a specified form. If the same specified form which is meant for intimation to the registrar, if it is signed by the charge holder, in such a case, no need of giving a notice to the charge holder to know about a cause or to inquire about show cause for not registering satisfaction in full within a period of 14 days. If any cause is shown by the charge holder, in case if any cause is shown by the charge holder, the registrar shall record a note to that effect in the register of charges and inform the company which has borrowed and which has intimated the registrar seeking about recording of satisfaction. So this is the second step. And next one is no effect of section 82 on the powers of the registrar. So section 82 shall not deem to affect the powers of the registrar to make an entry in the register of charges under section 83 on receipt of otherwise than on receipt of an intimation from the company, even if no intimation is received by him from the company. Also, the registrar in certain cases can record the satisfaction of charge in full in the register of charge maintained by him. And issue of a certificate. The registrar enters a memorandum of satisfaction of charge in full. He shall issue a certificate of registration of satisfaction of charge in form number CHG5. So these are the four steps regarding company to report to satisfaction of charge, which was given under section 82. So the initial step was to company has to intimate, and the next step is to the registrar has to give a show cause notice, and third step is to sometimes the registrar can record the satisfaction even without obtaining the intimation either from the borrowing company or from the holder of charge. And the fourth step was the issuing of certificate by the registrar to the borrowing company with respect to the recording of satisfaction of charge in the register of charges maintained by the register of companies. That was about the gist of the previous topic, and the same is also been given in a small flow diagram. And the next topic is the power of registrar to make entries of satisfaction and release in absence of intimation from the company. This is the third point in the earlier topic. In the absence of intimation from company, what are the powers that are conferred to the registrar to make entries of satisfaction under section 83? Section 83 of the Companies Act 2013 empowered the registrar to make entries with respect to satisfaction and release of charges even if no intimation has been received by him from the company. So accordingly, with respect to any registered charge, if an evidence, this point you need to remember. If an evidence is shown to the satisfaction of registrar that the debt secured by charge has been paid or satisfied in whole or in part, or that the part of the property or undertaking charged has been released from the charge or has ceased to form part of company's property or undertaking, then he may enter the register, then may he enter in the register of charges a memorandum of satisfaction that the debt has been satisfied in whole or in part, or the part of the property or undertaking has been released from the charge, or has ceased to form part of company's property or undertaking. This power can be exercised by the registrar despite the fact that no intimation has been received by him from the company. So, intimation to affected parties. Intimation to affected parties. The registrar shall inform the affected parties within 30 days of making the entry in the register of charges, and he is also having an obligation with regard to issue of certificate stating that the charge has been released. And the rule 8 2 says that in case the registrar enters a memorandum of satisfaction of charge in full, he shall issue a certificate of registration of satisfaction of charge in the form number CHG5. So the topic number 6 and 7 can be asked in your examination together, because both the sixth topic and the seventh topic in chapter number 6 deals with the release registering of satisfaction by the registrar in the register of charges maintained by him. So when there is no intimation from any side, what were the reasons and what was the requirements to the register of companies for recording of satisfaction has been given in section 83. The next topic is intimation of appointment of receiver or manager. Section 84 of the Act is about the appointment of a receiver or a manager and of giving intimation thereof to the company and the registrar. Accordingly, if any person obtains an order for the appointment of receiver, if any person obtains an order for appointment of a receiver or a person to manage the property which is subject to charge, which is the property which is in charge, with regard to that, if any receiver is appointed or a manager is appointed, if any person appoints such receiver or a person under any power contained in any instrument, he shall give notice of such appointment to the two parties. One is the borrowing company and the second is the register of companies, along with a copy of order or instrument within 30 days from the passing of the order or making of the appointment. In turn, the registrar, on payment of the prescribed fees, register the particulars of the receiver or the person or instrument in register of charges. On ceasing to hold such appointment also, on ceasing to hold such appointment, the person appointed as above shall give a notice to that effect to the company and the registrar. So whenever the person is ceased to be the receiver of the company, receiver of the property, or even the manager of the property which is subject to charge and registered with the register of companies, the second time it is the person who is responsible, whoever was appointed as above has to give a notice to that effect to the company and the registrar. In turn, the registrar shall register such notice. So this is all about intimation of appointment of a receiver or a manager to manage the property which was subject to charge and which was registered with the register of companies. And the next topic is punishment for contravention. If a company or the persons or whoever is responsible to comply with the provisions of the chapter charges, if they violate or contravenes any of the provisions relating to registration of charges or modification or satisfaction of charges, the punishment shall be like this. If it is a company, the company shall be punishable with the minimum fine of rupees 1 lakh and a maximum fine of rupees 10 lakhs. Apart from punishing the company, every defaulting officer of the company shall be punishable with the imprisonment, maximum up to 6 months, or with a minimum fine of rupees 25,000 and a maximum fine of rupees 1 lakh, or sometimes both the imprisonment and the fine also can be awarded. So, with the insertion of section 447 relating to the punishment for fraud also becomes applicable in certain cases. Accordingly, if any person willfully furnishes any false or incorrect information or knowingly suppresses any material information which is required to be registered under section 77, he shall be liable for action under section 447 also. This deals with a fraud, with a criminal intention, with an intention to cheat the someone else. In all such cases, they will be get attracted to punish under section 447. And the last topic here is that rectification by central government in register of charges. So under section 87, a rectification of register of charges can be effected. So the rule 12 empowers the central government to order a rectification of register of charges in the following cases of a default. When there was a omission in giving intimation to the registrar with respect to payment or satisfaction of charge within a specified time, then in such a case the rectification can be initiated. When there was a omission or misstatement of any particulars in any filing previously made to the registrar, such filing may relate to any charge or any modification of charge, or with respect to any satisfaction of charge or any other entry made under section 82. Before directing that, the time for giving the intimation of payment or satisfaction shall be extended, or omission or misstatement shall be rectified. The central government needs to be satisfied. Here, the central government need to be satisfied that such a default was accidental or due to inadvertence or because of some other sufficient cause, or it did not prejudice the position of creditors or shareholders. So if these are the grounds for giving effect of rectification to the register of charges, in all such cases the central government can initiate a rectification of charge register. So for such a case, the application shall be filed by the company, or any interested person also can make an application, and order of rectification shall be made by the central government on such terms and conditions as it deems just and expedient. So, according to Rule 12 of the Companies Rules 2014, the central government may, on an application filed in form number CHG8 in accordance with Section 87, direct the rectification of omission or misstatement of any particulars in any filing or previously recorded with registrar with respect to any charge or with respect to any modification thereof, or with respect to any memorandum of satisfaction or other entry made in pursuance of the sections 82 and or 83. So direct extension of time of satisfaction of charge also can be given. See, directly extension of time of satisfaction of charge also can be given if such filing is not made within a period of 300 days from the date of such payment or satisfaction. So direct extension also can be given. However, the condition is that the filing is not made within a period of 300 days from the date of payment. So in such a case, extension of time can be given, or in other cases, rectification of omission or misstatement can be get attracted, and in all such cases, the grounds for giving effect of rectification of register of charges is the mistake should have been happened accidentally or due to inadvertence, or because of some other sufficient cause, or it did not prejudice the position of creditors or shareholders. So in all such cases, the central government has to be get satisfied. Then only it will order for giving a direct rectification or a direct extension for satisfaction of charge. So, dear students, with this, the chapter number 6 is complete in all respects, and I thank you all. And this is a small and simple chapter. However, there will be enough number of questions that would likely to come out of this chapter, and where you can score maximum with little efforts if you are thorough with chapter 6. With this, I would like to conclude, and I thank you all with best wishes as always.